What we're hearing is that the judge has said that the state has failed to prove that this was a premeditated murder.
761, capital A in brackets, NR versus Koza, 1949, volume 4, 555, capital A in brackets. In terms of the rule then, because of A's intention to kill, A is guilty of the murder of C without the prosecutions having to establish an intention to kill C specifically. Recent case law, however, moved away from the ratio in Kuzwayo and Koza on the basis that that ratio was founded on the outworn doctrine of versari in illicita and could no longer be supported. The current South African law regarding criminal liability is set out in S versus Mchiza, 1970, volume 3, SA, page 747A. On page 752, Holmes J.A. explains the legal position as follows. I quote, I leave us something. Nowadays, criminal liability is not regarded as attaching to an act or a consequence unless it was attended by mens rea. Accordingly, if A assaults B and in consequence B dies, A is not criminally responsible for his death unless A, or the possibility of resultant death, yet persisted in his deed, reckless whether death ensured or not, or B, he ought to have foreseen the reasonable possibility of resultant death. In A, the mens rea is the type of intent known as dolus eventualis.
Well, let's just go back a little in time and listen into what the judge said when it came to the fact that whether or not this was a premeditated murder. Pretoria magistrate has said that Pistorius is not guilty of premeditated murder.
There is also the question of onus. No onus rests on the accused to convince this court of the truth of any explanation that he gives. If he gives an explanation, even if that explanation be improbable, the court is not entitled to convict unless it is satisfied not only that the explanation is improbable, but that beyond any reasonable doubt it is false. If there is any possibility, therefore, of his explanation being true, then he is entitled to his acquittal. See in brackets, C. Difford, 1937, capital A, capital D, 370, close brackets. The onus is on the state throughout to prove beyond reasonable doubt that the accused is guilty of the offense with which he has been charged. Should the accused's version or evidence be found to be reasonably possible true, he would be entitled to his acquittal. In count 1, the accused is charged with premeditated murder. In respect of this charge, the evidence is purely circumstantial. That evidence is in essence about shots, about the screams, and about sounds of the cricket bat. The fundamental rule in considering circumstantial evidence is that in order to justify an inference of guilt, a court must be sure that inculpatory facts are incompatible with the innocence of the accused and incapable of explanation on any other reasonable hypothesis. The simple explanation from the accused is that shooting the deceased dead was a genuine mistake